The Supreme Court just decided to take on another major Second Amendment case, and this one's all about concealed carry restrictions. What makes this particularly interesting is that it deals with laws that states created specifically to get around the court's previous ruling in the New York State Rifle and Pistol Association versus Bruin case from '63. This is really important news for gun rights advocates, so let's dive into what's happening with this case and how it's already affecting other similar legal battles playing out in courts across the country. Before we get into the details, I need you to do something really quick. Smash that like button right now if you care about protecting your Second Amendment rights. It only takes a second, and it makes a huge difference in getting this information out to more people who need it. Also, if you're not already subscribed to the channel, hit that subscribe button and turn on the notification bell so you don't miss any future updates on your rights. Trust me, you're going to want to stay informed about this stuff. The case that the Supreme Court agreed to review is called Wolford versus Lopez, and it's a huge deal for people living in states like New York, New Jersey, California, Hawaii, and several others. All of these states decided to put new concealed carry restrictions in place after the Supreme Court issued their Bruin decision. The Hawaii case, Wolford versus Lopez, asked the Supreme Court to step in on an emergency basis, and surprisingly, they actually agreed to hear it. The core issue in this challenge involves a preliminary injunction and a decision by the Ninth Circuit that said states can have these blanket bans on public property and that these bans are okay under the Second Amendment. Something really noteworthy happened recently when the Trump administration's Department of Justice and Attorney General Bondi actually came out in support of this challenge. They pushed the Supreme Court to agree to review this two-way case, and it looks like their effort worked. The Supreme Court granted review, which caught a lot of people off guard because this was an emergency review and it dealt with what's called an interlocutory issue. Normally, the Supreme Court stays away from these kinds of cases, but not this time. The fact that the Supreme Court took this case is already having ripple effects on other concealed carry cases that are challenging laws created in defiance of Bruin. There's a California carry ban case that has already been put on hold because the Supreme Court is now reviewing this issue. But things get more interesting with a case in New Jersey that's currently at the Third Circuit Court level. In that situation, the people bringing the lawsuit are actually asking the panel at the Third Circuit to keep moving their case forward even though the Supreme Court is now reviewing the Wolford case. Let me give you some background on what the Wolford case is actually about. This is a challenge to new concealed carry laws that Hawaii passed as their response to the Bruin decision. Hawaii's law, similar to laws in places like New Jersey, tried to add more hoops for people to jump through when it comes to concealed carry. They created this default rule where people can only carry firearms on private property if the property owner explicitly gives them permission to do so. Gun rights organizations and individual plaintiffs decided to sue Hawaii to get these laws thrown out. When the case went to a district court, that court issued what's called a TTRO, which stands for Temporary Restraining Order. Later on, this restraining order was converted into a preliminary injunction. The court made a determination that there was no historical precedent or tradition that would support Hawaii's blanket ban, and that's why the lower court ruled the way it did. Eventually, the case made its way up to the Ninth Circuit. At the Ninth Circuit, a three-judge panel looked at this case along with a California concealed carry ban case, and they ruled against the plaintiffs. They sided with Hawaii and decided that the blanket property ban was allowable. The reasoning they used was kind of nuanced. Since Hawaii's law would let property owners either give explicit permission or post a sign, the judges found that this was different from what other states like California were doing, so they allowed Hawaii's law to stand. When the plaintiffs asked for the full Ninth Circuit to review the panel's decision, that request was denied, which is what pushed this case up to the Supreme Court. And like I mentioned, the Supreme Court recently agreed to hear this case, despite it being on an emergency basis, and despite it dealing with an interlocutory issue. The Supreme Court probably broke from their usual practice of turning down these types of emergency cases for a couple of reasons. First, the state of Hawaii made some concessions when the case was at the Ninth Circuit level. Second, you had the United States government backing the plaintiffs and really pushing the Supreme Court to take the case. In a recent brief filed by the United States government as a friend of the court, they made some strong statements. They said that the near total ban is completely inconsistent with Bruin and the long history that underlies that decision. They pointed out that Bruin recognized that ordinary law-abiding citizens have a general right to publicly carry weapons for self-defense. One of the really interesting things in that brief from the Trump administration was how they pushed the Supreme Court to take this review on an emergency basis instead of waiting for a final decision on the merits. They also highlighted something important that the state of Hawaii had admitted at the Ninth Circuit level. Hawaii basically conceded that nothing else needed to be figured out or investigated at the lower court level. They said this was purely a legal question about the Second Amendment and that no additional evidence needed to be gathered or developed by the lower courts. Despite Hawaii making this concession, the Supreme Court disagreed with how Hawaii wanted things to proceed and decided to grant review to the case. When the Supreme Court announced they were taking the case, they released a statement that said the petition is granted limited to question 1 presented by the petition. So what exactly is the Supreme Court going to review? The question they'll be answering is whether the Ninth Circuit made a mistake when they held, in direct conflict with what the Second Circuit said, that Hawaii can presumptively prohibit licensed concealed carry permit holders from carrying handguns on private property that's open to the public unless the property owner specifically gives express permission to the person carrying the handgun. This means the Supreme Court is going to directly tackle these blanket property bans that were passed in defiance of Bruin in states like New Jersey, California, New York, Hawaii, and other states with similar laws. It's also pretty likely that when the Supreme Court rules on this case, they'll dig deeper into their previous Bruin decision and spell things out more clearly. They'll probably develop the framework a bit more and give better guidance to lower courts about what needs to happen after Bruin. This is important because lower courts have been all over the place in how they've interpreted and applied Bruin. Since the Supreme Court granted review, a few things have already started happening. First, there have been motions filed in several places asking courts to put other concealed carry cases and ongoing litigation on hold until the Supreme Court makes their decision on the Woolford case this term. And yes, they're going to rule on this during the current term. Some courts and some plaintiffs are asking for these cases to be paused. However, there's that one challenge coming out of New Jersey that I mentioned earlier, which deals with another concealed carry ban. The people involved in that case are asking for the full Third Circuit Court to review their case, and they don't want it held up while everyone waits for the Woolford decision. Instead, they're arguing that these cases and this whole issue is way too important to delay while waiting for the Supreme Court to review the Woolford case. They want their case to move forward at the Third Circuit level with the full court reviewing it. In their request, they point out something the panel already recognized, which is that this case raises a question of enormous public importance. They reference how the Supreme Court has confirmed that the Second Amendment protects a general right to publicly carry weapons for self-defense, and this right presumptively includes all places where the public gathers. The fundamental question their case poses is whether the exception is going to completely swallow the rule. If the Second Amendment isn't really a second-class right, then this case, which lets New Jersey indirectly ban what they couldn't target directly, deserves to be heard by the full court. Given how important this case is and the fact that the panel unanimously supported the district court's preliminary injunction against the private property default rule, a decision that the people challenging the law don't have a problem with, they argue the court shouldn't delay the full court rehearing just because the Supreme Court is now going to address that specific issue and none of the many other issues raised by this case and the Wilford versus Lopez case. So in this New Jersey carry ban challenge, the argument is that the court shouldn't put off having the full panel review the case just because of what's now happening at the Supreme Court level with the Wilford case. However, if I had to bet, I'd say the odds are probably pretty high that they will still put this case on hold. I think the Third Circuit full panel could take what would be the easier path and just say they're going to hold the case, because the Supreme Court is reviewing a blanket property ban. Now, maybe the specific issue in the New Jersey case isn't exactly the same. Maybe that particular aspect is being conceded by one side or the other. If the Third Circuit full panel wanted to take the path of least resistance, they could simply say they're going to pause this case until the Supreme Court rules on this similar carry ban issue. The second thing that's already developing is that we're starting to hear rumors that some states might try to change their laws, and Hawaii might be one of them. They might attempt to make these Supreme Court challenges moot by changing the actual statute and modifying the language in the law. This is a tactic we've seen used multiple times before. The state of New York has actually done this exact thing several times after the Supreme Court agreed to review two-way cases. So this is definitely something we're hearing whispers about. We haven't seen it actually happen yet, but there are rumblings that this could potentially be the strategy for some of these anti-gun states if they want to dodge this Supreme Court review and avoid the impact of whatever decision comes down. We'll definitely be watching these states closely to see if they try to sidestep the consequences of the Supreme Court case by attempting to remove or modify some of these vampire rules and blanket property bans. This whole situation is really significant for Second Amendment rights and for people living in states with restrictive concealed carry laws. The fact that the Supreme Court agreed to take this case, especially on an emergency basis, signals that they're taking these issues seriously. The involvement of the Trump administration's Department of Justice in supporting the challenge also adds another layer to the story. When you have the federal government coming in and saying these near total bans are completely inconsistent with previous Supreme Court rulings, that carries a lot of weight. The bottom line is that this is a major Second Amendment case with potentially far-reaching implications. Whether you're a gun rights advocate or someone concerned about gun regulations, the outcome of Woolford versus Lopez will likely have a significant impact on concealed carry laws and Second Amendment jurisprudence going forward. We'll be following this case closely and keeping you updated as new developments emerge and as the Supreme Court moves toward issuing their decision. If you found this information valuable, do me a favor and hit that like button right now. It helps get this critical information in front of more gun owners who need to know about these changes. And if you haven't subscribed yet, make sure you subscribe to the channel and turn on notifications so you never miss an update on your rights. Share this video with every gun owner you know because this information is too important to keep to yourself. Thanks for watching, and I'll see you in the next one.